South Korea's immigration detention reform and network global governance, mapping an undemocratic architecture of norms. Dongbo Choi, Handong International Law School, March 2026. Abstract. This article uses South Korea's move away from indefinite immigration detention to evaluate network global governance. In 2023, the Constitutional Court held that detention until deportation is possible violates constitutional liberty and proportionality, forcing legislative reform. Rather than reading this only as a domestic constitutional progress, the article shows how Korea's detention policy has been reshaped by a dense matrix of actors, UN body, UNHCR, treaty committees, NGOs, academics, media, and foreign funders who promote global compact on refugee, style norm through the advocacy, litigation, expert discourse, and soft law that is treated as a quasi-binding. This network evaluates minority elite preferences, narrows the space of democratic choice, and effectively steers the detention policy without clear popular consent. The article concludes by outlining a conservative democratic framework that both reject indefinite detention and restore self-government, distinguishing binding treaties from soft law, demanding transparent parliamentary debate, and grinding reform explicitly in Korea's own constitutional order. Part 1 Introduction Detention, Democracy, and Network Power. In March 2023, the Constitutional Court of Korea held that Article 63, Section 1 of the Immigration Act, which authorized the detention of non-citizens subject to deportation until deportation is possible, violated the constitutional principle of proportionality and due process and thus infringed the fundamental right to physical freedom. The court issued a decision of constitutional nonconformity, allowing the provision to remain temporarily in force but requiring the National Assembly to enact corrective legislation by May 31, 2025. For the first time, the Korean legal system explicitly recognized the indefinite immigration detention without a statutory upper time limit and without automatic independent review is incompatible with constitutional liberty. At first glance, this appears to be a straightforward story of domestic constitutional evolution. A high court, relying on familiar doctrine of liberty and proportionality, corrects an overbroad grant of executive power. Indeed, many Korean and foreign observers welcomed the decision as long overdue progress in aligning Korea's immigration detention regime with international human rights law, particularly Article 9 of the International Covenant on Civil and Political Rights, ICCPR, which prohibits arbitrary detention and requires that deprivation of liberty be necessary, reasonable, and proportionate. Yet, the decision did not emerge in a vacuum, nor will the legislative response that follows begin on a blank slate. Immigration detention policy in Korea is increasingly influenced by a dense transnational architecture of institutions and norms. The Global Compact on Refugee (GCR), adopted by the United Nations General Assembly in 2018, UN treaty bodies and special procedures, the Office of United Nations High Commissioner for Refugees (UNHCR), domestic and international non-governmental organizations (NGOs), academic experts, media outlets, the global funding network involving states, corporations, and private foundations. These actors generate standards, frame narratives, produce research, coordinate litigation, and apply reputational pressure on the national institutions to conform to their shared conception of international human rights standards. James P. Cowley III first described such an arrangement as a matrix of human rights governance network in which UN officials, NGOs, and experts and funders use interconnected advocacy, research, standard setting, interpretive, explanatory, implementation, assessment, enforcement, and funding activities to shape domestic economic and social policy. One need not adopt his full typology to take seriously his core warning that this network make it possible for international actors and domestic civil society elites to influence and sometimes effectively determines national law and policy outside traditional channel of the democratic consent. This article applies that insight to a single concrete field, immigration detention in Republic of Korea. It argues that Korea's transition away from indefinite detention has been driven not only by the internal constitutional reasoning, but also, and crucially, by a coordinated network of international organizations, domestic NGOs, academics, media, and funders who share the commitment to GCR style norms and who operate in a ways largely bypass direct democratic authorization by Korean voters. These actors do not necessarily conspire in a secret, rather, they mutually reinforce one another in a way that produces a de facto governance system standing above and around the formal democratic process. From the conservative constitutional perspective, the central question is not whether indefinite detention is desirable policy. Many conservatives committed to a limited governance and the rule of law will agree that the unlimited detention without an independent review is constitutionally suspect. The question is that who decides and according to what authority? Did the Korean people ever vote to adopt the GCR as a quasi-constitutional norm? Did they consent to treat UNHCR guidelines as authoritative in drafting their immigration law? Why do unelected international and domestic actors, often funded from abroad, wield such outsized influence over the shape of detention policy, while the preferences of ordinary voters are filtered only indirectly, if at all? To address this question, Part 2 maps the shape detention policy governance network currently operating in Korea, focusing on five clusters of actors: international norm-making and interpretive institution, domestic civil society, advocacy and litigation, academic and knowledge production communities, media and narrative entrepreneurs, and funding network. Part 3 explains how this network taken together subvert or bypass the traditional democratic processes by converting non-binding norms formally into quasi-binding expectation, leveraging court and media to narrow the range of politically acceptable options, and amplifying the minoritarian preferences as if they were the voice of the international community. Part 4 shows how this dynamic converged in the 2023 Constitutional Court decision and subsequent redrafting of Immigration Act. Part 5 asks whether Koreans ever actually consented to this legal trajectory, focusing on the legal status and democratic legitimacy of the GCR and related instruments. Part 6 concludes by suggesting how Korea might end indefinite detention without surrendering control of the detention policy to a transnational network lacks direct democratic accountability. Part 2 Mapping Detention Governance Network in Korea. The core thesis of article is that Korea's immigration detention policy is increasingly shaped by the ordinary electoral politics, but not by a network governance structure of domestic and international actors whose authority is largely technocratic rather than democratic. This part maps those networks in 5 dimensions and illustrates how in a specific context of detention, they function together as an informal but powerful system of international governance that can circumvent domestic sovereignty and democratic accountability. A. International norm making and interpretive actor. At the apex of the network standard international institutions that generates, interprets, and promote general norms concerning immigration detention. Three are particularly salient in a Korean debate: the Global Compact on Refugee, the ICCPR and its monitoring bodies, and UNHCR and related special procedures. The Global Compact on Refugees was affirmed by the United Nations General Assembly in December 2018 through the Resolution 73-151, which is affirms the compact set out in Annex Section 2 to the High Commissioner's annual report. Although the resolution is explicitly described as non-binding, the GCR articulates a detailed framework of international cooperation in refugee situations, including the principle that the detention of asylum seekers should be used only as a measure of last resort for the shortest possible period and preferably replaced by the community-based alternatives to the detention (ATDs). The Republic of Korea joined the overwhelming majority of states in voting in favor of Resolution 73-151, but GCR has never been ratified as a treaty or incorporated by the statute in a manner that would render it binding domestic law. Nonetheless, in Korea detention debates, the GCR is frequently invoked by the UNHCR, NGOs, academic writers, and even government actors as a standard that the Korea must implement to be a responsible member of the international community. That move from non-binding political document to quasi-binding standard is a signal feature of the network governance model. The ICCPR, by contrast, is a former treaty that Korea ratified in 1990, and the Article 9 of the Covenant has long been understood to apply immigration detention. The Human Rights Committee, which monitors ICCPR implementation, has interpreted Article 9 to require that any detention be justified as reasonable, necessary, and proportionate in light of circumstances, and that immigration detention should be an exceptional measure of last resort rather than a default response to irregular migration. B. Domestic civil society, litigation, and advocacy. At the national level, the international normative framework is internalized and operationalized by a network of Korean civil society organizations, lawyers, and professional associations. These actors play a central role in identifying problematic detention practices, advancing individual and strategic cases, and relying on information upward to UN mechanism and global NGOs. Korean refugee support information upward to UN and Korean refugee support and migrant rights NGO conduct detention monitoring, provide legal aid, and publicize cases of perceived abuse. Public interest lawyers and NGO affiliated attorneys bring constitutional complaints, administrative suits, and habeas like challenges on behalf of detainees, often focusing on particularly sympathetic cases such as minors, families, or individuals with serious health conditions. APIL, Advocates for Public Interest Law, for example, describe its litigation on behalf of the long-term detainee and its use of a submission to UN mechanism as a part of a broader effort to improve the human rights situation of refugees and migrants in Korea. Similarly, NCCN Refugee Rights Center, one of the Korean refugee supporting NGO, presents its work as combining legal assistance, policy advocacy, and public education in order to improve refugee-related laws, policies, and systems consistent with human rights. Professional associations, including the Korean Bar Association and regional Bar Human Rights Committee, issue reports and statements criticizing indefinite detention and calling for legislative reform in accordance with international standards. Likewise, the National Rights Commission of Korea, NHRCK, a constitutionally grounded but independent body, conduct the annual on-site investigation of immigration detention facility has repeatedly criticized overcrowding and prison-like conditions and has explicitly recommended that the Ministry of Justice adopt alternatives to detention for asylum seekers and others in long-term custody. In October 2024, for example, the NHRCK urged the Ministry of Justice to actively implement ATDs, such as temporary release of refugee applicants and litigants, explicitly tying its recommendations to the purpose of detention under the Immigration Act and to international norms that treat long-term detention of asylum seekers as inconsistent with human rights. In a separate statement responding to the Human Rights Committee's 2023 concluding observation, the NHRCK chairperson welcomed the committee's recommendation on improving the treatment of asylum seekers and foreign detainees and called on the government to act. These domestic civil society and quasi-official actors interact closely with the international body. NGOs submit shadow or parallel reports, independent civil society submission that the supplement and when necessary, contest the state's periodic report by documenting implementation gaps and rights violations to UN treaty bodies, often accompanied by a concrete question and recommendation for concluding observation. NGOs also provide evidence for global detention projects and other international monitors and participate in regional RTD, ATD working groups convened by the UN network. UNHCR, in turn, cites Korean NGO and NHRCK finding in its own report and submissions to Constitutional Court and the National Assembly. This mutual reinforcement exemplifies the network model. Domestic and international actors validate one another's claim creating a thick, normative environment in which indefinite detention appears not simply controversial, but already condemned by a settled body of human rights doctrine. C. Media narratives and sad story politics. The third component of the network consists of legacy and new media, which transfer legal and academic discourse into public narratives, often centered on emotionally gripping stories of individual detainees. Major newspaper and broadcaster have run stories highlighting harsh conditions in immigration detention facilities, including overcrowding, lack of outdoor access, extended use of surveillance and restraint, and comparisons to criminal incarceration. Coverage of the 2021 to 2022 Moroccan detainee case is illustrative. In that incident, a Moroccan asylum seekers held that Hwasong Immigration Detention Center was filmed lying on the floor in restraint with the cable ties around his limb and the helmet-like devices on his head. The footage, initially recorded by the detention staff, was widely circulated online and reported by the national media outlet with the headlines such as "Where Have Human Rights Gone?" and "Moroccan Asylum Seekers Outcry for Humane Treatment of Detainees." The article described the detainee as being bound like an animal and highlighted criticism from NGOs and human rights experts, prompting the Ministry of Justice to announce the measure to improve the treatment of the detainees. New media, YouTube channel, social media account, and the online news platform amplify these stories with the video footage, interviews, commentaries, frequently framing them as evidence that the Korea is failing to meet its human rights obligations. University outlets such as Dankook Herald have run features on immigration detention titled Where Have Human Rights Gone? And echo NGO language and call for legislative reform. In many cases, the narrative is explicitly linked to the GCR, ICCPR, and UNHCR guidelines, with commentators asserting that indefinite detention is already prohibited by international law and that Korea must act quickly to avoid international embarrassment. NGO and UNHCR actively cultivate this media ecosystem. They issue press releases, hold press conferences, and provide ready-made case summaries and talking points to journalists. UNHCR's Korea's country communications emphasizes engagement with policymakers and its effort to ensure that refugees and asylum seekers are considered in domestic reforms, implicitly encouraging media to review national policy through the lens of UNHCR's priorities. The resulting sad story politic has real governance effect. It becomes reputationally costly for political actors to defend tougher detention policies or to raise concerns about pull factors in the enforcement capacity, because such positions can be portrayed as a callous or xenophobic in a media environment saturated with human interest stories and international condemnation. D. Funding and corporate philanthropy. Another and often least visible component of the network is funding. Human rights governance networks are sustained by the governments, multilateral institutions, corporations, and private foundations by selectively financing advocacy, research, standard setting, and enforcement initiatives that align with the preferred norm. UNHCR's operation in Korea, including its policy engagement and detention-related work, are funded by a mix of assessed and voluntary contributions from state as well as private and corporate donors. UNHCR itself reported that its work is almost entirely funded by the voluntary contributions from governments, intergovernmental institutions, and hundreds of companies and millions of private individuals through national partners. The UN Board of Auditors financial report confirms that the overwhelming majority of UNHCR's revenue derives from voluntary contributions, not the UN's regular budget. Global foundations such as George Soros Open Society Foundation have well documented programs supporting the migration and refugee advocacy, including projects aimed at ending immigration detention and scaling up ATDs. And they channel resources through international regional network that collaborates with local partners. Open Society Foundation's Migration and Asylum program, for example, describes a grant to the organizations working on refugee rights, asylum, and alternatives to detention worldwide. Specialized grant platforms such as Fund for NGOs maintain section on refugees, migration, and asylum seekers, advertising funding opportunity for NGOs seeking to work on these issues. Corporate actors participate through the corporate social responsibility and environmental, social, and governance initiative, often partnering with UN agencies or NGOs to support human rights projects related to refugees and migrants. In this environment, Korean NGOs and academic centers advocating for GCR consistent detention reform can draw on multiple funding streams. For example, foundation support for migration asylum work, for example, George Soros Open Society Foundation's migration and asylum programming, and donor IGO linked grant opportunities for refugees and migrant initiatives cataloged through the NGO grant portals, enabling long-term campaign, research project, and media outreach. By contrast, there is no compatible funding network for actors who might wish to defend more restrictive detention policy, emphasize national sovereignty, or advocates for stricter border control consistent with domestic border preferences. Ordinary Korean citizens who bear the social and political consequences of migration policy participate mainly through periodic election where detention is rarely a central issue and lack organized, well-funded platform dedicated to their perspective on detention. The asymmetry is structural. The global money consistently amplifies one side of detention debate, the side favoring time limits, ATDs, and GCR implementation, while the other side is left to rely on diffuse, unorganized voter sentiment. This does not mean that every policy outcome is determined by the foreign funding, but it does not mean that institutional ecosystem is heavily tilted toward one normative vision of detention. Third, how network bypass and pressure the democratic process. With the network in place, it becomes easier to see how, taken together, these actors circumvent or pressure democratic decision making in Korea's detention policy. This part identifies five recurring mechanisms: the elevation of soft law into quasi binding standards, the transformation of the minority elite preferences into moral dogma, the judicialization of policy change, the construction of media-driven illusion of consensus, and the entrenchment of asymmetrical funding. First, soft law becomes quasi-binding. Formally, the GCR is non-binding UN General Assembly resolution that expresses political commitment and cooperative frameworks rather than legal obligation. UNHCR guidelines, Executive Committee conclusions, and Working Group reports are likewise non-binding interpretive instruments. Yet, in practice, Korean NGOs, academics, NHRCK officials, and UNHCR itself speak as if these documents impose real obligation. Detention must be a last resort, must be a time limited, and Korea must implement ATDs. Treaty bodies concluding observation, even though not binding in the same way as treaty text, are similarly treated as authoritative judgment that Korea is expected to heed. This elevation of soft law is accomplished by a single actor, but not but by a chorus of institutions that repeat and cite one another until the norm acquire an aura of inevitability. Courts and legislature are then told that they have no real choice if Korea wishes to remain in good standing with the international community. Second, minoritarian preferences become more dogma. The core design of GCR and UNHCR's detention guideline reflects the preferences of relatively small community of international officials, academics, and NGO advocates deeply committed to broad refugee protection and the presumption against immigration detention. Within that community, the claim that detention should gradually be abolished and replaced by the ATDs is close to an article of faith, but there is little evidence that this position in full strength reflect the considered preferences of median voter in Korea, who may simultaneously wish to avoid abuse and to maintain firm control over the irregular migration. Nevertheless, once international and domestic elites frame the GCR and the related norms as international human rights standards, dissent becomes difficult. Politicians who express skepticism may be portrayed as hostile to human rights. Academics who question the wisdom of or legitimacy of self-law internationalization risk marginalization. Put differently, marginalization operates not only at the level of public discourse but within the knowledge of infrastructure of the network itself. Funding streams, access to detention data, and peer review gatekeeping can channel scholarship toward the paradigm consistent frame that are readily legible to transnational governance actor. To see how the thick normative environment is built, we must therefore look at academic production as a node in the same network. A further mechanism that thickens this normative environment is the production of expert knowledge within the university and quasi-academic research center. Much of the empirical work on immigration detention and alternatives to detention ATDs, including facility monitoring, case documentation, survey work, and policy evaluation, depends on sustained funding and access to data. In practice, the support can come through project-based resource associated with international organizations and major philanthropic foundations as well as grant ecosystem in the refugee migration space. The finance long-term campaign, research project, and public outreach. This funding-linked research ecosystem may generate predictable methodological incentives. Projects are often designed around the deliverables that are legible to transnational policy workflows, toolkits, indicator, and implementation facing evaluation, thereby privileging research that operationalize detention reform as a technical management problem over work that interrogate legitimacy questions surrounding soft law internalization and democratic authorization. The structure of data access further constrains academic debate. A significant portion of detention-related empirical evidence is generated through NGO monitoring, litigation support case files, and human rights institutions investigations. Data sets that are costly to build and difficult to replicate independently. As a result, scholars may become reliant to partner organizations for field access, interview recruitment, and administrative records, which can narrow the range of claims that are feasible to sustain, especially when dissenting finding a risk, reputational, or access costs. Moreover, the peer review model itself can operate as a gatekeeping mechanism in a field with strong moral priors. Peer review is indispensable for quality control, but where baseline assumptions above the detention and ATDs are treated as a settled, challenging work may be filtered out through the fit, reviewer selection, and norms of acceptable framing. This is less a matter of overt censorship than of structural selection effect, which can make an apparent scholarly consensus partly a function of institutional pathway through which evidence is produced and validated. Third, the courts are tuned into engines of policy change. Litigation strategy development by the NGOs and public interest lawyers encourage courts to read international norms into constitutional concepts, thereby upgrading non-binding expectation into hard domestic law. The Constitutional Court's 2023 decision on Immigration Act Article 63, Section 1 is a case in point. While the court grounded its holding in domestic proportionality and due process doctrine, it explicitly treated an enforceable time cap and independent control as constitutional requirement, stating that the law should at least specify the upper limit to prevent harm caused by the unreasonable prolongation or uncertainty of detention period, and that due process requires that the validity of detention be examined and controlled by the neutral body independent of its executor. The court also situated these requirements within the comparative and international reference points, noting, for example, that international standard and foreign legislation such as UN Working Group on Arbitrary Detention and EU returns rule proceed on the premise that the maximum detention period is necessary because indefinite detention risks serious human rights violation. Once the court has spoken, the legislature's role is constrained. The only remaining question is how, not whether, to implement the new norm. Fourth, the media helps construct an illusion of democratic consensus. When coverage of the detention is dominated by the stories of highlighting egregious abuse and strong international criticism, and when the only experts consulted are aligned with the GCR paradigm, the public may be left with the impression that everyone who is informed and dissent support detention reform is the same direction. Little attention is given to a specific trade-off, such as potential increasing in absconding, enforcement burdens, or signaling effect that might concern voters. In this way, what is essentially a network generated consensus is presented as a democratic consensus. Fifth, asymmetric funding locks in this structure over time. Because global funding streams consistently support actors promoting ATDs and GCR style norms, they can maintain institutional continuity, staff expertise, and the media presence across many years and political cycle. There is no comparable investment in organizations whose mission is to defend national sovereignty, to represent voters skeptical of expensive refugee protection, or to articulate a conservative constitutional approach to migration control. In the long run, this imbalance shape which arguments are institutionally available, which are seen as respectable, and which are silently excluded. None of these mechanisms is in itself unlawful. They are rather predictable feature of the system in which governance power flows through the network of elites and institutions whose incentives or loyalties are only loosely connected to domestic electorates. The question, from the conservative democratic standpoint, is whether Korea can reform its detention practices without allowing this network to displace the Korean people as ultimate author of their own law. 4. Part 4. The 2023 Constitutional Court decision and legislative redrafting. The 2023 Constitutional Court decision on Article 63, Section 1 of the Immigration Act provides a concrete illustration of how detention government network and domestic constitutional processes intersect. The case arose from consolidated petitions challenging the legality of prolonged detention of the foreigners subject to deportation order. The petitioners include individuals who had been detained for extensive period without a clear prospect of removal, as well as a highly publicized case involving an infant detained with her mother. The Suwon District Court and the Seoul Administrative Court referred constitutional questions to the Constitutional Court, arguing that Article 63, Section 1 lacked a maximum detention period and failed to provide the independent review, thereby violating physical freedom and the principle of proportionality. In a 6 to 3 decision of constitutional nonconformity, the court agreed. It held that the absence of a statutory upper limit time, combined with the lack of automatic review by an impartial and neutral body, resulted in excessive and potentially indefinite restriction of personal liberty. The court emphasized that the detention under the Article 61, Section 63, Section 1 is an administrative measure intended to secure the enforcement of deportation order, not a punishment, and thus must be strictly limited to what is necessary to achieve the purposes. It also noted that many democratic statements maintain clear maximum detention period and judicial oversight mechanism in the immigration detention, treating these as a relevant comparative practice. Although the court did not explicitly cite the GCR, it expressly invoked the international standard and foreign legislation, citing the UN Working Group on Arbitrary Detention's view that the upper limit of custody shall be specified in the law, and, and that detention may not be unlimited, while warning that detention without a time limit may lead to serious human rights infringement. In this sense, the detention can be viewed as a convergence point. Domestic constitutional doctrine and international norm reinforce one another, producing a ruling that both Korean and international actors can celebrate as a victory. Yet the path to this decision had been prepared by the year of advocacy, research, and international criticism. The Global Detention Project and other international NGOs had long documented Korea's use of open-ended detention without maximum time limits. The NHRCK had repeatedly recommended the introduction of time limit and ATDs. UNHCR had publicly and privately criticized indefinite detention and had submitted a written intervention in a case decided in 2023, stressing that the detention is only legitimate within a reasonable period necessary to enforce deportation and calling for impartial control and opportunity for detainees to be heard. After the court decision, the focus shifted to National Assembly and Ministry of Justice, which were tasked with the drafting amendment to the Immigration Act by 2025 deadline. Here too, the network quickly mobilized. UNHCR issued a detailed comment on the government's legislative proposal in early 2025, setting out expectations on maximum detention periods, periodic judicial review, special protection for children, and implementation of ATDs, and stating that its comments were offered in light of the supervisory responsibility under Refugee Convention and Article 29 of the Korea's Refugee Act. Domestic NGOs and academic experts voiced their own critics and proposals often align closely with UNHCR's recommendation. The Ministry of Justice proposed limiting detention for those under deportation orders to maximum of 3 years and incorporating certain review mechanisms, but critics argue that proposal did not go far enough to embracing ATDs or ensuring robust judicial control. Media coverage framed the debate in terms of whether the government was fully complying with the Constitutional Court's decision and the international standards, again using language drawn from UNHCR and NHRCK statement. Korea Times, for instance, ran stories warning that the foreign detainees, including those with criminal records, could be released if the National Assembly failed to pass the amendments before the court deadlines, dramatizing the stake of legislative inaction. Thus, while the court decision was formally an exercise of domestic judicial authority, its contents and its implementation trajectory cannot be understood apart from the broader detention government's network. The court's reasoning drew on norms already articulated and promoted by the international and domestic actors, and each ruling in turn triggered a legislative process heavily supervised, normatively if not legally, by those same actors. Part 5. Did Koreans ever consent? GCR, self-execution, and legitimacy. From a conservative democratic perspective, the most troubling aspect of this story is not that Korea has moved away from the indefinite detention. Few would defend the constitutionality of unlimited detention without independent review, but that it has done so within a governance structure that largely bypasses direct popular consent. The GCR is the centerpiece of the new international orthodoxy on refugee protection and detention. It was adopted by the General Assembly as a non-binding framework, and Korea supported the resolution. But the Korean electorate was never asked whether it wishes to accept the compact's normative contents as a guide for domestic law. There is no referendum on the GCR, no explicit electoral mandate centered on its implementation, and no parliamentary debate treating it as a quasi-constitutional document. From a legal standpoint, the GCR is not self-executing. It does not create directly enforceable rights in Korean courts, nor does it have supremacy over domestic statute under Korean constitutional law. Yet, in practice, Korea's detention policy is increasingly described in terms of implementing the GCR, and UNHCR's comments to the National Assembly explicitly frame their recommendations as necessary for compliance with the Compact and related norms. This raises a simple but profound question. If a non-binding UN resolution is treated as effectively binding by the domestic elites and institutions, what remains of the distinction between law and politics, or between international persuasion and domestic self-rule? Proponents of the network governance might respond that the Korean state, exercising its sovereignty, chose to support the GCR and to establish cooperative relations with UNHCR, that the ICCPR, as a ratified treaty, already obliges Korea to avoid arbitrary detention, and that the court decision is grounded in its own constitutional tradition. All of this is true to the point, but it does not fully answer the democratic objection. The GCR and the UNHCR guideline do not simply restate ICCPR Article 9. They embodied a particular, expansive interpretation that presses state toward reducing or abolishing immigration detention in favor of ATDs. That interpretive choices has never been presented to Korean electorate as a policy choice, nor is the Constitutional Court required as a matter of doctrine to treat the GCR or UNHCR guidelines as an authoritative source of constitutional meaning. A conservative constitutionalist might therefore argue for a different approach to the relationship between international norm and domestic law. One attentive not only to rights protection but also democratic legitimacy and institutional competence. In practice, judicial adoption of contested transnational framework can function as a form of policy displacement. Issues that would predictably generate electoral contestation are resolved through the constitutional adjudication, with court, however independent, operating as elite venue that can entrench positions that have not been won through ordinary democratic politics. The ICCPR, once rectified, bind Korea under international law, but its domestic effect should be mediated by the constitutional framework, and the interpretive choices about controversial issues, such as extent to which immigration detention should be limited, should be made transparently by national institutions that are accountable to the people. International instruments such as the GCR can be taken into account, but they should not be treated as authoritative unless formally incorporated through the democratic processes. In other words, the normative content of Korea detention law should ultimately be traced to the Korean constitution and to the decisions of the Korean people through their elected representative, not to the policy preferences of the international agencies or transnational NGOs. However, well funded or well intentioned and not to judicialized shortcut that converts contested policy preferences into constitutional mandates without the discipline of democratic consent. Part 6. Conclusion. Ending indefinite detention without ending self-government. South Korea's move away from indefinite immigration detention is a genuine constitutional advance. By requiring meaningful limits and independent review, the Constitutional Court strengthened the protection of physical liberty and constrained administrative discretion. This article has argued, however, that the reform's significance lies not only in the rise of outcome, but in the mode of governance through which it was achieved, one increasingly shaped by the transnational norm and domestic actor who translate soft law expectation into constitutional doctrine and legislative agendas. The task ahead is therefore to preserve the liberty-protecting gains of detention reform while insisting that the content of immigration policy remains anchored in democratically accountable institutions and in constitutional principle openly debated and authorized at home.